But right now, what we are faced with, or what everybody should be concerned about, is the post-judgment regime. Nnamdi Kanu still retains his constitutional right to fair hearing under Section 36 of the Constitution. That constitutional right is going to be expressed before the Court of Appeal. Or perhaps there could be some post-judgment maneuvers that could be made before the High Court. But for now, it is well known to the whole world and to the court, the High Court, and to everybody else who is a stakeholder in this case, that Nnamdi Kanu has no legal counsel. So as I speak, he still represents himself. But see, after the sentencing, I was surprised, and I think everybody else who was monitoring this case was surprised that he was plucked from Abuja and taken all the way to Sokoto, which is in the northernmost part of northwest Nigeria. So you begin to ask, how can he effectively prosecute his appeal, or even take the initial steps towards initiating his appeal? Initiating an appeal is not an easy thing to do. He has to file a notice of appeal, he has to request for the transcripts of the record of proceedings before the High Court, pay for them, review them, and do all sorts of things, all sorts of activities that will now play out before the Court of Appeal. And these things require his personal, physical presence to get these things accomplished, unless he hires a lawyer. And up to this point, he hasn't indicated that he's going to hire any lawyer, or he has not made known to anybody that he has hired any lawyer. So you begin to wonder whether he will be able to prosecute this appeal from his prison location in Sokoto. The Sokoto division of the Court of Appeal doesn't have jurisdiction over this case. It's the Abuja division. So putting him in Sokoto, I know it is true. It is not the fault of the judge. It is the fault of the executive branch. Once someone is sentenced, it becomes the property of the executive branch, in particular the correctional service. So that decision to put him in Sokoto perhaps did not take into account these concerns that I'm expressing. It is very insensitive to his rights. Prisoners do have rights. That you are in prison doesn't mean you have lost your rights under Chapter 4 of Nigerian Constitution, your fundamental rights, in particular Section 36, which is really what is relevant now. Can Nnamdi Kanu effectively prosecute his appeal or even initiate it from that location in Sokoto? The answer is no. So what I think may play out in the coming days or weeks is to seek ways and means of ameliorating the detention conditions. The judge did not particularly order that he be detained in Sokoto. There was only one prison in Nigeria that was excluded, and that was the Kuje prison. But, you know, if you check around Abuja area, the environs, there are other prisons in the vicinity. We have one in Suleja, we have in Kefi, and there are probably other prisons within 2 hours of Abuja. Those prisons would have been much better locations for detaining Nnamdi Kanu, to ensure that he's close enough to his relatives who are known to be in Abuja, his legal consultants if he wants to deploy their services. Also, is also very close to the Court of Appeal in Abuja, which has jurisdiction over this matter, and so on and so forth. So we're looking at a situation where his right to appeal is being complicated by the current location of his imprisonment.
All right, Mr. Ajimako, a few things.
My heart was heavy, and the mayor George Ahunwe Iwe Dimonobi. Believe it or not, a politician, they are given to diplomatic language, diplomatics, and all that. I'm not giving to that. I saw all the problems. The Ikbe Wakatal wicked. Ọbụ na mbiri n'ọtọ ga wee microphone o ihe nga agwa onye ọka ikpe sie ikpe gị nke gbakọtara wicked alụ emego na nkwuchazie nya o visitzie anga ya iwe ya on Maazị Nnamdi Kanu ka ọ ga-esi wee dị ekwutelụ m ya nụnụ So consider the consequences of ihe nkwesị ikwu. So I deadpanned, but inside me I was boiling. Anyị nwa with legal team nwere suspicion. Every legal team na-enwe intelligence based on assessment of the situation. Otu case nwere ike isi wee ga. Enwe otu case ahụ si na-aga. I now prepare our mind for the worst. We were hoping for the best, but preparing for the worst. Oh yeah, ihe mere. So mgbe ahụ worst ahụ bịara ewere onye fenti ịnọ. Ọ bụ na anyị prepare for the worst, maybe agara m efent. So obi nwoke ka eji wee kwụrụ gịrịgba wee die ndidi ahụ disie ya ike. Words na-enwe consequences, mana ọ bụrụ otu a, before words enwe consequences, ọ ga-enwe word and effect. Kedu effect o nwee? Kedu ihe ọ resọtụrụ into? Ewere onye si na ihe Maazị Nnamdi Kanu kwuru mere o ji wee tụọ ofu iche, ofu okwute. Not to talk of na onye ahụ ji maka ya je gbuo mmadụ or commit ihe a na-akpọ act of terrorism. Mmadụ na mmadụ kwuru okwu na London ma na Kenya, even agwara anyị ebe ọrụ mee broadcast nwanụ. Anyị amakwanụ ma enwelu ndị nwa na commit terrorism fanụlụ ya. Kere ebe o kwuru ya ọ na BBC or maybe n'internet. Ọ bụ onye ọbụla nwere internet, a na-enwe onye bịa forward sị na ihe a Nnamdi Kanu kwuru mere m ji wee je gbuo mmadụ or m ji wee je commit act of terrorism. So all in that situation ka okwu na-enwe consequences. So evidence anọrọ na before the court. Ewere onye wetere such evidence. Ọ ya mee ihe m ji wee kwuo na mmadụ adịghị eje nga just merely because of ihe o kwuru n'ọnụ, unless enwere overt act. Ihe lawyers na-akpọ overt act and connection, nexus between the overt act and the spoken word. Ekwesịrị enwe criminal consequences. Well, I enwetego ihe a na-akpọ CTC. Before you may appeal of any judgment, you get to go to certified true copy of the judgment. Nke I went all the 144 pages, almost like a book. So I get you weekend that study anya. By Monday or Tuesday, I just file a court of appeal, file a notice of appeal. Even though I went 90 days, I actually reached 90 days. Obi the ayoko or the ayon say so. Kai na the halls of justice. Jemalung haye meba. And then when I court of appeal, a discharge go Nnamdi Kanu before. So I just court of appeal. How can I wonder? Can we hear a work out here again? Or why a discharge get since 2022? So somebody has to explain that too. I've always believed in this case the more political than legal. We are from Mido. Ihe ji wee webata ya na-eme no legal, maybe because no onye Igbo. Ndị nke ọzọ yitebere kwere ya, like chairman ndị mietiala, isetele ya politically. Emesili arrest, emesili federal government say happier because ha believe na enwe political something nọ ya. Nke so ndị Igbo ho, the same thing. Buhari chụkatara ya ọsọ chụfe ya Niger, Benin Republic. Emesịa onye abata n'ọchịchị mbụ onye Tinubu akpọghachitie all political settlement bụ ihe a. Nke showerekwa bụkwa the same thing. President of Nigeria onye awa ọga kpatakpata obi n'ihe echi si na okwu a edosigo m ya kpọnụ m Nnamdi Kanu ka anyị kpaa nkata otu Obasanjo shi wee kpọọ asarị ha akpọ Ụwazirike ọ Jonathan kpọrọ Ụwazirike ụdị ihe a na-eme Tom Polo ha kwana and all that biko no ya na aghọgbu ibie. So ọ na President Tinubu say I put a stop to this, he will stop.